When Sylvia Mendenhall got off a plane at the Detroit Metropolitan Airport in 1976, she had no idea the encounter she was about to have with a few agents from the Drug Enforcement Agency would raise certain questions about consensual stops that would go all the way to the Supreme Court and further help differentiate between what constitutes a consensual stop and what should be considered a violation of an individual's Fourth Amendment rights. Upon disembarking a flight from California, Ms. Mendenhall was approached by two DEA agents who identified themselves as police officers and asked to see her ticket and identification. Ms. Mendenhall handed over her driver's license, which contained her photograph and the name Sylvia Mendenhall. She stated that the information on her driver's license was correct. However, when she produced her airline ticket, the agents noticed the ticket had been issued to Annette Ford. While it was legal to travel under an assumed name at that time, it was still peculiar enough to cause suspicion. When asked about the use of the name, Ms. Mendenhall simply stated she just felt like using that name. When asked how long she'd been in California, she again simply stated 2 days. At that point, the officers specifically identified themselves as federal narcotics agents, and, according to Agent Anderson's testimony, Ms. Mendenhall became quite shaken and extremely nervous. She had a hard time speaking. Agent Anderson returned her driver's license and airline ticket, but also asked her to accompany him to the airport DEA office for further questions. She agreed. This office was up a flight of stairs and about 50 feet from where their conversation began. Once there, Agent Anderson asked Ms. Mendenhall if she would allow a search of her person and her handbag. He also told her that she could refuse if she desired. She responded, "Go ahead," and handed Agent Anderson her purse. Soon thereafter, a female police officer arrived to search Ms. Mendenhall. The officer asked Ms. Mendenhall again if she agreed to the search. Ms. Mendenhall again said that she did. The officer explained that the search of her person would require Ms. Mendenhall to remove her clothing. Ms. Mendenhall took this opportunity to remind the agents that she had a plane to catch. The officer said there would be no problem if she didn't find any drugs. Ms. Mendenhall's response was to begin disrobing. The officer soon thereafter found controlled substances on Ms. Mendenhall. Ms. Mendenhall's defense would later move to suppress the evidence of the controlled substances found on her person due to what they claimed was an unlawful search and seizure. This case boils down very quickly into 3 questions. 1. Did the agents seize Ms. Mendenhall in the airport terminal? Spoiler alert, no, they did not. The agents were not in uniform. They did not display weapons. They did not call Ms. Mendenhall over to them. They were in a public area. They spoke to her in terms of requests rather than demands. The court decided the agents, therefore, did not seize Ms. Mendenhall in the terminal. The second question is, did the agents' request to relocate Ms. Mendenhall to the nearby office convert the conversation into a seizure? Another spoiler alert, no, it did not. The question of whether Ms. Mendenhall's consent to go with the agents was voluntary is determined by the court's analysis of the facts under the always popular legal test, the totality of all the circumstances. The court found no coercion existed to the facts that the agents simply asked Ms. Mendenhall if she would accompany them. They did not threaten or show force of any kind. The engagement was brief, and the agents had returned her ticket and identification before they asked her to accompany them. Which leaves us with the third and final questions. If the agents did not unlawfully detain Ms. Mendenhall, and if they did not coerce her into cooperating, is there anything else the court would consider before deciding this case? What about Ms. Mendenhall's statement that she had a plane to catch? The court held that this was reasonably interpreted as an expression of concern that the search be conducted quickly. What of Ms. Mendenhall's claim that because she was within the DEA office when she consented, her consent was the result of the inherently coercive nature of those surroundings? The court concluded that her presence in the DEA office was the result of her voluntary actions. And finally, what of Ms. Mendenhall's claim that no one in their right mind, that is, a non-coerced mind, would voluntarily consent to a search that was likely to result in the discovery of contraband? The court's response was they were not interested in whether Ms. Mendenhall acted in her own self-interest, but only whether she acted voluntarily. They found that all available facts and circumstances indicated she did act voluntarily, and the evidence and resulting conviction was upheld. And the story of the Fourth Amendment continues on. I'm Lauren Ware, and this has been a FLETC Talk.